As you know, it's been a tough week for the prosecutors trying to put former President Trump on trial, particularly in Georgia, where the lead prosecutor is now no longer on the case. Nathan Wade tendered his resignation after a scathing ruling from a judge forced his boss, Fani Willis, to choose between removing her entire office from their election interference case or removing Wade. Now, joining me now is Ed O'Callaghan. He is a former federal prosecutor. He also was a top Justice Department official in the Trump Justice Department. You also helped to oversee the Mueller investigation. So I'm really interested to get your take on what happened yesterday with the judge in Georgia.
So it was a very interesting decision by the judge in Georgia yesterday. He essentially chose to give Fani Willis the option of whether she herself would be removed from the case or the prosecutor that she had appointed in particular to run the case against Donald Trump and the co-conspirators. Mr. Wade essentially resigned, which I think was the right thing for him to do. And so Fani will remain as the DA on the case. She now has to find a top prosecutor to replace Mr. Wade. It is no small matter when a judge removes a prosecutor from a case, but I think this judge has been doing a pretty remarkable job in the face of what anyone would assess to be kind of a circus in the courtroom well before any trial is to take place. And he's dealing with the issues as they come before him, and making rulings that he thinks are in the best judgment to keep the case moving forward.
Yeah, a young judge, been on the bench just about a year,
right,
and then has to handle this question of whether her entire office should be disqualified because Fani Willis and Nathan Wade had a romantic relationship. The defendants were claiming that she financially benefited. The judge said that they did not actually prove that allegation, but you've been involved in a high-profile investigation related to former President Trump. You have to be, basically the Pope, right? You have to be beyond reproach. What is your reaction to what transpired here?
Yeah, I think the judge appropriately laid forth some of his concerns, to say the least, about what the evidence in the hearings displayed, which were some ethical issues for sure. And look, as a prosecutor that has the responsibility to represent the people in bringing a case, you do want to be above reproach. Obviously, we're dealing with human beings, but the fact of the matter is you're held to a higher standard. And that standard is when you represent the people of the state of Georgia or in federal court, the people of the United States, that there should not be any doubt about the existence of any conflict of interest, even the appearance of a conflict of interest. And what I think we saw was there was plenty of conflict of interest here, and I think the judge did his best given the difficult facts that were presented before him.
I want to turn our attention to Manhattan. The Manhattan District Attorney's case against former President Trump was expected to be the first criminal trial.
Right.
It was scheduled to begin in a week. But over the past few days, they suddenly received tens of thousands of pages of evidence from your old office,
right,
the Southern District of New York, the federal prosecutors in Manhattan. So now the judge is holding a hearing a week from now to figure out if he needs a new trial date. How does something like this happen, where suddenly tens of thousands of pages of evidence are turned over from federal prosecutors to the state prosecutor?
Yeah, I have to tell you, Paul, it's incredibly unusual in my experience that given where, obviously we know the Southern District of New York had some cases, most prominently the Michael Cohen case, and presumably some of these documents are coming from their cache of documents that were developed in their investigation of that case. But that case has been long over. Michael Cohen has already served his jail sentence and he's back out. And so I find it difficult to understand what it was that prevented Southern District from giving the Manhattan DA's office whatever they were asking for that was relevant, either inculpatory information or exculpatory, frankly, even more importantly, for the defense. In my experience, and as a Southern District of New York prosecutor, there was a strong rivalry with the Manhattan DA's office frankly, the only time that you would keep information from another prosecutor's office that is representing to you that they can use it either in a case that's already charged or to further investigate is when I thought I still had investigative avenues to pursue. And I thought that there was something in that cache of documents that I wanted to make sure I ran to ground. Now, I'm not saying that I'm aware of anything like that happening in the Southern District of New York. That's really the only justifiable reason I could imagine that they didn't immediately turn it over at the request of DA Bragg.
So I want to look down to Florida, the classified documents case. It's been 2 weeks now. We've been waiting for the judge to set a new trial date in that case. There are some questions about whether that case will go before November. What is your assessment of that case and whether it can realistically go before the election? And is that a product of the judge or is it just the nature of the case?
Yeah, I think that it's going to be difficult in my assessment for that case to go before the go to trial before the November election. There are a number of circumstances that have a lot of bearing on that. One is just the nature of the charges. The judge did rule against Mr. Trump and his effort to dismiss the Espionage Act charges on unconstitutionally vague arguments. She did say it was without prejudice, which actually can prove a little troublesome for the prosecutor, that they still might have to deal with that down the road. But she's at least moved that along. But in terms of what's really the difficult part of that case is all of the classified information that's involved in it. There are procedures in cases involving classified documents. It's Classified Information Procedures Act, which there have been some hearings in that. But the fact of the matter is, because those hearings take longer, this judge is unfortunately a little bit unfamiliar with those proceedings. I just think it's going to take longer to hash all that through. And that basically is, the judge has to make rulings when the prosecutor says, on discovery for the defendant to defend themselves against certain allegations, they don't necessarily need access to all the classified material that might be implicated in the case. And she's got to make some pretty strong rulings saying that the defense does not need that. And that's a difficult thing for judges to do. They are inclined to, frankly, provide as much discovery as a defendant wants. But in classified document cases, it's a different beast, and she just doesn't have familiarity with it. So I think it's just going to take longer.
Another arguably inexperienced judge. All right, so we talked about 3 of the 4 criminal cases against former President Trump. The calendar is crowded, it's confusing, it's uncertain. Do you think any of these cases are going to go before the election?
Yeah, I do think the Manhattan DA case will go before the election. I think the Judge Merchan there has shown that he wants to push this case forward. I think that they will figure out this discovery. There may be some quote unquote bombshells that come out in the discovery which lead to more motion practice, but that seems like it is teed up to go before trial. And the other case, of course, that we haven't talked about is the January 6th case that is pending before the Supreme Court on the issue of whether the president should have absolute immunity from prosecution. If you look at the timing of that case, it is pretty interesting. They've set the oral argument in the Supreme Court for April 25th. That means it's likely that a decision on that comes out with the rest of the end of term opinions, which is end of June. Arguably, because there's only one defendant, that's only, Mr. Trump in that case, there's an argument that case could be set before Judge Chutkan here, who's also indicated that she wants this to go to trial, sometime late September, early October. It's possible. You then bump up against the DOJ policy, of course, of whether or not you actually bring
and they
cases.
said it doesn't apply here in a criminal trial. They broke that news 2 weeks ago in court.
I think that there is frankly, a more typically nuanced common sense application of that policy than what was strictly represented there. I do think that at the end of the day, everything would turn out that they don't push to do that trial before the election as well. But I could see the schedule working out that trial does go before the election.
Fascinating. We'll have you back to talk about all of it because it's going to be a busy year.
Yeah,
lots of trials, maybe.
Yeah,
we'll see.
We'll see.
Etta Callahan, thank you so much.
Thank you, Paula.